Good morning, ladies and gentlemen. Today we are going to study a very important module which talks about public interest litigation. Before coming down to the chapter, I would like to focus on the learning outcomes that after the study of the chapters, the listeners will be very conversant with. The learning outcomes of this chapter will basically be in-depth understanding of the concept of public interest litigation, its evolution and development in Western countries and India, locus standi and its liberalization in PIL cases, and contribution of PIL in the attainment of social justice. What comes to your mind when you hear these three words public interest litigation? It basically means litigation filed for safeguarding the interest of the public at large. It may be taken to mean action initiated in a court of law for the enforcement of public interest or general interest in which the public or a class or community has pecuniary interest or have some interest because it will affect their legal rights or liabilities. So, understanding this, it becomes very clear that public interest litigation is a litigation filed for the welfare of the people at large or of the downtrodden masses. Coming to the specific definition, a very good definition of public interest litigation has been given in Black's Law Dictionary, 6th edition. It says, I quote, something in which the public, the community at large has some pecuniary interest or some interest by which their legal rights or liabilities are affected. It does not mean anything so narrow as mere curiosity or as the interest of the particular localities which may be affected by the matters in question. Interest shared by citizens generally in affairs of local, state or national government. When we analyze this definition, we see certain important points which relates to who can file public interest litigation. It says that for any matter in which the public or the community at large has a pecuniary interest, and by that interest, the infringement of that interest causes greater harm of the people, then a public interest litigation can be filed to enforce that particular right. Justice Bhagwati, who is supposed to be the propounder of public interest litigation in India, has given a very good definition of public interest litigation in the case of S.P. Gupta versus Union of India. He, in this decision, altogether dismissed the traditional rules of standing and replaced it with a liberalized modern rule. He said that where a legal wrong or a legal injury is caused to a person by reason of violation of any constitution or legal right, or any burden is imposed in contravention of any constitutional or legal provision or without authority of law, or any such legal wrong or legal injury or illness, burden is threatened and such person or determinate class of persons is by reason of poverty, helplessness or disability or socially or economically disadvantaged position unable to approach the court for relief, then in that case any member of the public can maintain an application for an appropriate direction, order or writ in the High Court under Article 226 or in the Supreme Court under Article 32. After understanding the meaning of public interest litigation by the definition given in the Black's Law Dictionary and by what Justice P.N. Bhagwati, the propounder of public interest litigation, has quoted in the case of S.P. Gupta versus Union of India, we come down to a very important concept which the readers must know or which the students must understand in order to understand this very innovative or a different kind of litigation which is not like the adversary kind of litigation. It is innovative, it is different, and this litigation is public interest litigation. So, now I would try and explain the nature and purpose of public interest litigation, which has been extensively explained by Justice P.N. Bhagwati, the father of the propounder of public interest litigation in India, because he was the one who coined this word public interest litigation, which basically means the litigations for the poor and downtrodden masses in the case of People's Union for Democratic Rights and others versus Union of India and others, which is popularly known as the Asiad labor case. In this case, the nature and purpose of public interest litigation was very beautifully explained by Justice P.N. Bhagwati. He said that public interest litigation is a strategic arm of the legal aid movement. Why did he say that it is a strategic arm of the legal aid movement? The readers need to understand that for understanding the nature of public interest litigation, we need to know that it is not, this type of litigation is not being explained or quoted in any of the statutes of India, but it is an innovation or it is developed by the various judicial pronouncements which the judiciary has given from time to time. When we say that it is a strategic arm of the legal aid movement, we mean, or Justice Bhagwati meant, that it is one weapon in the arm of the legal people where they could find justice for the people of all strata, and it aids to the already prevailing legal aid movements. It strengthens the legal aid movement. It is something on which a firm foundation of legal aid movement can be laid. Secondly, he said that it intends to bring justice within the reach of the poor masses. When we say that it intends to bring justice within the reach of the poor masses, Justice P.N. Bhagwati meant that India is a country where the population is, a big portion of the population is poor, illiterate, downtrodden, or if literate or affluent also, is ignorant. And in these cases, the justice is brought to the reach of the poor masses because the relaxation of the concept of locus standi makes it possible not for the aggrieved only to move to the court, but any other person who has a bona fide intention or who is a public spirited individual or an organization who wants to work in the welfare of the public at large, then it is not only the aggrieved who has to move to the court, but anyone on behalf of these poor masses can move to the court and ask for justice for these poor masses. So it brings justice within the reach of the poor people or the downtrodden society. Moving on further, it is said that public interest litigation is a different kind of litigation from traditional litigations. As I have already quoted a number of times that it is different from traditional litigations, I would just give a few points that how it is different from traditional litigations. In traditional litigations, there is a strict concept of locus standi followed where only the aggrieved can move to the court. But as I have already explained, in public interest litigation, any public spirited individual or an organization can move to the court asking or seeking for justice for the poor, downtrodden or ignorant masses of the society. Secondly, there are no strict procedures to be followed, or we can say that it is not compulsory to file a litigation only by writing a plaint. In the public interest litigation, even telegrams by prisoners or letter petitions, or we can say the suo motu cognizance of the cases have been taken up by the judiciary in a number or a series of cases. To quote a few, we can say Sunil Batra versus Delhi administration, or we can talk about the inmates of Agra home where an eminent jurist or an eminent writer, Professor Upendra Bakshi took up the matter of the plight of the Agra home inmates. Fourthly, it is said that it is brought before the court not for the purpose of enforcing rights of one individual against another. This kind of public interest litigation does not provide for punishing of the offender, but it says that in public interest litigations, there should be a remedy which should be sought, or there should be a solution which should be found out by the two parties involved in the case and the state asking finding out the remedy, how to overcome the existing problem. So in this, the rights are not enforced against each other, but it is a solution which is found out by the collaborative and cooperative effort of the state and the court to make social justice available to the different sections of the community. When I say it is a cooperative or collaborative effort, it means that not pitting against the two parties, not being pitted against each other, but the two parties working together in cooperation and collaboration to find out a solution to the already existing problem in the society. Moving on next to how PIL developed in India. Though PIL in India developed in 1970s, but there is a long history behind it. We have adopted this concept of public interest litigation from the Western countries, which existed in USA long back in the name of social interest litigations or social actions litigations. In America, if we see, there are big foundations like the Ford Foundation who has been supporting the lawyers, and it is a big developed industry in the city of New York where a large number of lawyers or the law firms or organizations are engaged into such kind of social action litigations, and they not only bring justice to the society but also are earning a lot of money through such litigations. In India, we have adopted this concept from America, or we can say that we have taken up this concept of social action litigation from America, seeking that our society in India also needed justice, and justice not only for a few or for a rich people, but also justice for the downtrodden masses of the society. So, in India, the public interest litigation emerged as a part of legal aid movement directed towards the protection of downtrodden masses of the country. Now, coming down to the evolution of PIL in India, we can say that in India, public interest litigation emerged as a part of legal aid movement directed towards the protection of downtrodden masses of the country. Justice P.N. Bhagwati explains the emergence of the concept in one of his articles, Social Action Litigation, the Indian Experience. In this, he said that the judiciary has to play a very vital role not only in preventing and remedying abuse and misuse of power, but also in eliminating exploitation and injustice. And on these lines, he propounded the doctrine of, or we can say he propounded public interest litigation in the Indian jurisprudence. And it was largely due to the efforts of the judiciary that PIL has been effectively conceptualized, and it is now in the process of being institutionalized. PIL has come to be recognized as an effective weapon in the arm of the law for securing implementation of the constitutional and legal rights of the underprivileged segments of society and for ensuring social justice to them. Coming specifically to the cases which contributed in the evolution of PIL in India, I would like to start with the seeds of the concept which was sown initially by Justice Krishna Iyer in 1976 in Mumbai Kamgar Sabha versus Abdul Bhai, and which were initiated in Akhil Bharatiya Shoshit Karamchari Sangh versus Union of India. In this case, an unregistered association of workers was permitted to institute a writ petition under Article 32 of the Constitution for the redressal of common grievances. Krishna Iyer enunciated the reasons for liberalization of the rule of locus standi, and in Fertilizers Corporation Kamgar Union versus Union of India, he liberalized this concept, and he said that the traditional rule of locus standi can be liberalized in the case of public interest litigation, just as to ensure that justice reaches the doorsteps of all the masses. The idea of public interest litigation blossomed and grew again in the case of S.P. Gupta and others versus Union of India. Coming down to specifically to locus standi and PIL, I would like to explain this concept because it plays a very major role in public interest litigation. In the traditional doctrine of locus standi, it is said that only the aggrieved person can go to the court and ask for a remedy. But in cases of public interest litigation, it says that where a person who is downtrodden, poor and ignorant and does not have means to approach the court, in that situation, any public spirited individual or a person with a bona fide intention can move the court in the name of public interest litigation. The decisions of the Supreme Court in the 1970s loosened the strict locus standi requirement to permit filing of petitions on behalf of marginalized and deprived sections of the society by public spirited individuals, institutions and bodies. If the cases of the decades of 70s and 80s are analyzed, most of the public interest litigation cases which were entertained by the courts are pertaining to enforcement of fundamental rights of marginalized and deprived sections of the society. This can be termed as the first phase of the public interest litigation in India. Basically, for the understanding of the people, or for the understanding of my students, I would like to say that PIL is divided into broad three phases. First, dealing with the social justice, second, dealing with ecology and environment, and third, dealing with good governance. So, this loosening of the principle of locus standi, or we can say the liberalization of the concept of locus standi, started in the first phase, which aimed at social justice through public interest litigations. Basically, the rule of locus standi was relaxed for the first time in Bar Council of Maharashtra versus M.D. Dhablorkar and others, where the court observed that a new class of litigation, public interest litigation, where a section or whole of the community is involved, emerges in a developing country like India, which better fulfills the rule of law if it is to run close to the rule of life. Here, rule of life meant that for the survival of the poor masses, speedy justice, cheap justice and quick justice to be provided to those people through the means of public interest litigation. In the case of Mumbai Kamgar Sabha, Bombay versus Abdul Bhai Faizulla Bhai and others, the apex court made conscious effort to improve the judicial access for the masses by relaxing the traditional rule of locus standi. The foundations of change in the society were laid down by the case of Husnaira Khatun and others versus Home Secretary, State of Bihar, Patna. In this case, Justice P.N. Bhagwati again observed that the poor in their contact with the legal system have always been on the wrong side of the line. They have always come across law for the poor rather than law of the poor. The result is that the legal system has lost its credibility for the weaker section of the community. From this moment of inception of the Husnaira Khatun case, it helped to establish the most important features in PIL. That is, a petition need not be filed by a person whose own legal rights are at issue. It was also said by the Honorable Court that it can be brought by any public spirited citizen, need not be based on personal knowledge, but can be supported by material like newspapers, articles, both important legal principles, and substantial relief can be created at prelim stage, and scope of litigation can be extended beyond the initial petition. This means that PIL does not only provide a remedy, but also provides a solution to the already existing problem. In Prem Shankar Shukla versus Delhi administration, another very important case which laid the foundation of change in society, a prisoner sent a telegram to a judge complaining of forced handcuff on him and demanded implicit protection against humiliation and torture. The court gave necessary directions by relaxing the strict rule of locus standi. Again, in another very important case in People's Union for Democratic Rights and others versus Union of India, the court observed that PIL, which is a strategic arm of the legal aid movement and which is intended to bring justice within the reach of the poor masses, is a totally different kind of litigation from the ordinary traditional litigation, which is essentially of an adversary character. We say it is of an adversary character because in this, the court procedures of the traditional litigations need not be observed in totality. Now, moving on to another very important segment of public interest litigation, it is preference of litigational competence over aggrieved person. It means that the distant feature of public interest litigation actions with their foundations in the Constitution and as a tool of citizens' participation call for a distant and flexible principle of litigational competence, and the concept of aggrieved person as understood and relevant to the invocation of the justice delivery system stands substituted by the principle of litigational competence as soon seen to be appropriate to public interest litigation. It means that if a person needs justice, his ends are met by relaxing the traditional doctrine of locus standi in preference of litigational competence over aggrieved person. The flexible principle of litigational competence is seen to be appropriate to public interest litigation as compared to aggrieved person. The court has tried to place persons in any of the following category. The court said that persons duly affected or injured, whether or not belonging to any class or group, persons whose pursuits relate to advancement of causes dealt with or regulated by any particular statute, persons engaged in rendering assistance, aid or support to the disadvantaged or disabled sections in espousing issues of public welfare, persons in public life or of repute, eminence, or a complete stranger or a busybody or meddlesome interloper, all are entitled to file public interest litigations if they come with clean hands and with bona fide intentions. Now coming down to the second phase of development of public interest litigations, we are going to study the preservation and protection of ecology and environment. The second phase basically started sometime in the 1980s and specifically relates to the court's innovation and creativity, where directions were given to protect ecology and environment. Very leading case in this phase was MC Mehta and others versus Union of India and others. This was the earliest cases brought before the Supreme Court related to oleum gas leakage in Delhi, and the court in this case clearly laid down that an enterprise which is engaged in a hazardous or inherently dangerous industry, working in the factory and residing in the surrounding area owes an absolute and non-delegible duty to the community to ensure that no such harm results to anyone on account of hazardous, dangerous nature of the activity which has undertaken. The court directed the enterprises that they must adopt higher standards of safety, and if any harm results on account of such activity, the enterprise must be absolutely liable to compensate for such harm. In another case of rural litigation and entitlement, Kendra Dehradun and others, was the state of UP and others, AIR 1985 SC 652, the Supreme Court ordered closure of all limestone quarries in the Doon Valley, taking notice of the fact that limestone quarries in the area had adversely affected water springs and environmental ecology. These all cases were not filed by the aggrieved, but was filed by public spirited individuals for the better good of the society as a whole. In this case, PIL has emerged because of the court's interpretation of Article 21 of the Constitution. 21 was given a wider interpretation, and the cases of protection and preservation of environment were entertained as public interest litigation cases. In another leading case of Kshetriya Pradushan Mukti Sangharsh Samiti versus State of UP and others, it was observed that every citizen has fundamental right to have the enjoyment of quality of life and living as contemplated by Article 21 of the Constitution of India. Anything which endangers or impairs by conduct of anybody, either in violation or in degradation or derogation of laws, that quality of life and living by the people is entitled to take recourse to Article 32 of the Constitution. It basically means that where a person's life is endangered because of any activity of the state, then in that case, a person can take recourse of the courts and ask for a remedy under Article 32 of the Constitution and approach the Supreme Court directly. In the case of Vellore Citizens Welfare Forum versus Union of India and others, the Supreme Court ruled that precautionary principle and the polluter pays principle are part of the environmental law of the country. This court declared Articles 47, 48A and 51AG to be part of the constitutional mandate to protect and improve the environment. In another very important case of MC Mehta versus Kamalnath and others, where the public trust doctrine was evolved by the court, the apex court was of the opinion that Articles 48A and 51AG have to be considered in the light of Article 21 of the Constitution. This court also laid emphasis on the principle of polluter pays. According to the court, pollution is a civil wrong it is a tort committed against the community as a whole, and a person therefore who is guilty of causing pollution has to pay damages or compensation for restoration of the environment and ecology. Coming down to the third phase, which is the current phase, which began with the 21st century, is a period in which anyone could file a PIL for almost anything. But does this not overburden the courts with cases? The answer is that almost for every case, though PIL is allowed, but the courts have become very cautious in entertaining the cases under the name of PIL. They say that it is not an attractive name by which you can file public interest litigations, but it should be only for the welfare of the people as a whole that these kind of litigations on strict scrutiny will be entertained as public interest litigations. One can argue that it is time for judicial introspection and for reviewing what courts try to achieve through PIL. As compared to the second phase, the judiciary has seemingly shown more restraint in issuing directions to the government. Although the judiciary is unlikely to roll back the expansive scope of PIL which they have already entertained in the first and the second phase, it is possible that it might take more measured interventions in the future. One aspect that stands out in the third phase deserves special mention. In continuation of its approval of the government policies of liberalization in Delhi Science Forum, the judiciary has shown a general support to disinvestment and development policies of the government. The recent phase, that is the third phase in particular, deals with the directions issued by the courts in maintaining the probity, transparency and integrity in government. The probity in government is a sine qua non for an efficient system of administration and for the development of the country. An important requirement for ensuring probity in governance is the absence of corruption. So we can say that the third phase of the PIL is leading towards effective and good governance. After having an in-depth or an insight into the meaning, nature, scope and the phases or the developments of public interest litigations by the courts in different phases, now we can conclude by saying that public interest litigation jurisdiction was innovated essentially to safeguard and protect the fundamental rights of poor, ignorant or socially or economically disadvantaged persons. The misuse of public interest litigation jurisdiction by the people resulted in flood of invasive and vexatious litigations in the courts. It follows in waste of vulnerable time of the Supreme Court and High Courts which are already burdened with huge amount of pending cases. The suppression and separation of such litigations from genuine litigations became the great task for the Supreme Court and High Courts. The court has refused, keeping this in mind, the court has nearly refused to entertain cases that have private interest or are private interest litigation disguised only as public interest litigations. However, as long as the thirst for justice remains yet to be fully slaked, and as long as the hunger for justice remains yet to be fully appeased, public interest litigation will continue to hold its unique attraction, not only in pursuit of justice for the privileged and affluent few, but more importantly in the pursuit of justice for all. With this, I come to an end of the module and I hope the listeners had a deeper insight of what public interest litigation is all about. Thank you.